Employees that have a medical condition or injury that affects one or more of their major life activities are part of a protected class. In California, the Fair Employment and Housing Act, also known as FEHA, requires that employers treat this protected class, known as the disabled employee, in certain defined ways. A failure to follow the FEHA requirements can result in an employer having significant financial exposure, even if the employer is unaware that it's doing wrong. FEHA obligations exist independent of any other statutory obligation that the employer may have related to injured or disabled employees, such as the Workers' Compensation System, the Family Medical Leave Act, FMLA, the CFRA or the California Family Rights Act, or any other statute that deals with sick or injured employees. It is the intersection between FEHA and these other related statutes that often causes confusion and gives employers either a reason to violate FEHA or allows them to violate FEHA without even knowing they're doing so. My experience as a disability discrimination litigator has shown me over the years many examples of when employers have either unknowingly violated the Fair Employment and Housing Act or have used these other statutes as a plausible basis for violation of the Fair Employment and Housing Act. In this video, I want to show you or talk to you about the 10 most common violations of the Fair Employment and Housing Act that I've seen employers do with regard to the disabled employees that work for them, and to hopefully, for those employers out there watching this that want to do it right, they can learn to do it right. For those people who represent employees who have been injured or have a medical condition and need representation, for you to recognize these red flags of violations. And for those employees out there who have had one of these serious medical conditions, to understand your rights related to the Fair Employment and Housing Act. California's FEHA disability-related provisions apply to all employers of at least 5 employees in the state of California. The statute found in Government Code Section 12940 and following sections defines several unlawful employment practices, including making it unlawful to discriminate against an employee because of their physical or mental disability or condition, an anti-retaliation provision, a provision that makes it unlawful to harass an employee based upon their disabled status, a provision that requires employers to engage in all reasonable efforts to prevent disability, harassment, or discrimination, a provision that requires employers to provide a reasonable accommodation to allow an employee to return to work and do their job if certain accommodations can be made that would allow as much, and there's a provision that requires employers to engage in a timely, good faith, interactive process with the employee to determine whether or not the restrictions that the employee comes back to work with would allow the employee to continue to perform the essential functions of their job and return to that job. Case law and administrative regulations have further defined these obligations, which would allow employers to understand what those obligations are. But unfortunately, there are still many employers in California who either don't know those obligations or choose not to follow their obligations. Therefore, I now will go into the 10 most common violations I have seen related to FEHA's disability discrimination provisions in no particular order. Common violation number 1, what I call the TTD misapplication. In the workers' compensation system, an employee is entitled to temporary disability benefits if they have been determined to be TTD or TPD. TTD means temporarily totally disabled. TPD is temporarily permanently disabled. Unfortunately, employers and the workers' compensation adjusters who often advise them on this apply a common English dictionary definition to those terms, and by doing so, walk away from the obligations that they have under the Fair Employment and Housing Act. As such, when a doctor would say to an employer through a doctor's note that they find the employee to be temporarily totally disabled, the employer believes that the employee is totally disabled in all senses of the word. This is a critical mistake for employers because an employer's obligations under FEHA exist regardless of the employee's status or label in the workers' compensation system. Case law has clarified that even an employee who is totally disabled, 100% disabled under the workers' compensation laws, is still entitled to be reasonably accommodated if accommodations are available. That was a case decided a few years ago called Quiet versus City of Los Angeles. Depending on the nature of the injury or the condition, an employer must still engage in a timely, good faith, interactive process with the employee anytime the employee returns to work with any kind of a restriction other than a restriction that says the employee may not work. That after engaging that timely, good faith, interactive process, the employer must provide any reasonable accommodations that are identified through the interactive process, as long as doing so would not create an undue hardship on the employer or create a risk of injury to the employee or to others. However, on several occasions, I have been told in deposition and in trial by employer representatives or workers' compensation adjusters who were advising them related to FEHA, not workers' compensation, that they believed that they had no obligation whatsoever to engage in the timely good faith interactive process or to provide reasonable accommodation to an employee until they were permanent and stationary in the workers' compensation system, and that was a critical legal mistake. Common violation number 2, what I call the no light duty deflection. Often when an employee suffers some type of injury or condition, they return to work with certain restrictions. Those restrictions might be the inability to lift more than a certain amount of weight, or they can't bend or twist or do certain physical activities. They may have to stand or sit for certain periods of time. And sometimes the doctor will simply note light duty work only. When the employee then brings that note back to the employer has an obligation to look at the note and those restrictions and to determine whether or not there is a way that the employee can be accommodated so that they can continue to perform their job. The problem is that a common response by many employers when they get a note back that says light duty work only is that the employer says, sorry, we don't offer light duty work, and they send the employee home. A rote, across-the-board policy that makes such a response is an outright violation of the Fair Employment and Housing Act. The law requires that an employee, when presenting that note to the employer, be allowed to participate in a good faith, interactive process with the employer, whereby the employer and the employee talk about the restrictions, talk about what that employee's particular job functions are, to determine if there are ways that the workplace or the process can be modified that would allow that employee to still continue to perform the essential functions of their job if certain changes were made. Common violation number 3, what I call the FMLA, CFRA blinders. The FMLA, Family Medical Leave Act, is a federal law that requires employers of qualified employees to provide up to 12 weeks of protected leave. The CFRA, or California Family Rights Act, is a similar California statute. Both of these statutory schemes require employers to provide these qualified employees with up to 12 weeks of protected leave time to address their own medical conditions or the conditions of close family members. And many employers understand these two statutes. They have standardized policies and procedures and forms that address each one of them. But unfortunately, it appears very common that these very same employers have blinders on with regard to the obligations under the Fair Employment and Housing Act to provide additional leave. Let me explain. Most of these employers understand FMLA and CFRA require 12 weeks of protected leave. And so at the end of that 12 weeks, a very common thing that I see is that when that 12 weeks is over, the employer informs the employee, your 12 weeks of protected leave are over, therefore you are terminated. And that is not the law under the Fair Employment and Housing Act. FEHA actually acts as a safety net under those federal and state statutes that require 12 weeks of protected leave, whereby under the Fair Employment and Housing Act, the employer is required to consider granting extended leave beyond that 12 weeks, could be for as much as 1 or 2 years, depending on the circumstances of each individual case. So when an employer looks at the 12 weeks required by FMLA and CFRA, and they put those 12-week blinders on, they fail to recognize that they are violating the Fair Employment and Housing Act by then terminating the employee after the end of that 12-week period of time. And that is a violation of the law. Common violation number 4 is what I call termination deadlines. Similar to the 12-week deadline I just spoke about that employers get so focused on related to FMLA and CFRA, I find many employers, especially very large employers, who create uniform policies that say an employee will be terminated if they are not able to return to work within a certain defined period of time, such as 1 year. Any uniform application of that type of a policy is usually going to be a violation of the Fair Employment and Housing Act. As I said earlier, FEHA requires employers to look at each employee's situation on a case-by-case basis. In one particular case that I had, an employee would have been able to return to work without restrictions 1 year and 3 months after he went out on leave. But because this particular large employer had a 1-year policy of termination, he was terminated just 3 months before he would have been able to return to a job that was basically a job that many other people in the workplace were able to do, so there was no undue hardship on the employer to keep that employee on the books but off on disability for 3 more months. As much as employers, especially large ones, would like to create clear, bright line, black and white rules that relate to how they should be treating disabled employees, doing so will likely result in a violation of the Fair Employment and Housing Act. Common violation number 5, the no restrictions policy. During my career, I have seen dozens and dozens of employees who have come to me and told me that their employer has told them that they cannot return to work as long as they have any restrictions whatsoever on their ability to perform the job. Whether that's because the employer is afraid the employee is going to get hurt or because the employer doesn't want to deal with the trouble of accommodating that employee, that is a violation of the law if there is a way to reasonably accommodate those restrictions. Refusing to take an employee back based on a no restrictions policy violates the employee's rights under the Fair Employment and Housing Act because the employer has the affirmative duty to look at restrictions and accommodate restrictions if there is a way to do so without creating undue hardship on the employer or without creating injury to the employee or to others. Therefore, a flat-out no restrictions policy is an admission of a violation of the provision of FEHA that requires them to engage in a timely, good faith interactive process, and is likely a violation of the duty to provide a reasonable accommodation because, by definition, they're not willing to consider accommodating it because they're not willing to talk to an employee who comes back with restrictions. The next common violation never ceases to amaze me. The employer actually starts out by doing the right thing. The employee shows up with a return to work notice with restrictions, and they're temporary restrictions, while the employee is being treated and healing. And those restrictions are accommodated by the employer in some way. They either modify the workspace or put the employee in a job where they can do the job without additional restrictions. But at some point in time, the restrictions become permanent. Sometimes in the workers' compensation process, the employee is determined to be permanent and stationary, or something to that effect. And all of a sudden, the employer, when faced with permanent restrictions, decides that they can no longer accommodate the employee and instead tell the employee that their restrictions cannot be accommodated permanently, and they send them home. This is generally going to be a violation of the Fair Employment and Housing Act. Just because restrictions turn from temporary to permanent does not change the affirmative duty of the employer to provide accommodations to the employee. And once these accommodations are going to be permanent accommodations, the only way the employer can legitimately back away from the accommodations that had been provided for some period of time is to establish that providing the accommodations permanently would result in an undue hardship to the employer. The thing is, since the employer had allowed the employee to work with these accommodations for some period of time, by definition, they weren't creating an undue hardship. And so in most situations, the employee is going to be able to establish that the employer pulling those accommodations is a violation of the Fair Employment and Housing Act. This next common violation goes hand in hand with many of the other violations I've spoken about in this video, but it is a standalone issue. And the issue is when the employer fails to engage in any interactive process with the employee. Oftentimes you will see a situation where the employee shows up to the employer with a return to work note that has restrictions, and the employer says, "Great, we'll get back to you." And then sometime later, the employer comes back with some unilateral statement about the employer's position. We will accommodate you, we won't accommodate you, this is the accommodation that we'll give you. The law requires that the process be interactive, meaning that there has to be communication between employer and employee about the employee's job requirements, the employee's restrictions, and what can be done to reasonably accommodate those restrictions so that the employee can continue to perform the essential functions of their job. A unilateral decision by the employer is the antithesis of interactive process, which is required. And so when you have an employer that simply unilaterally states, this is what we're going to do, they are likely violating this independent legal duty under the Fair Employment and Housing Act to engage in a timely, good faith, interactive process. Common violation number 8, employer-created ambiguities that result in delay. Some employers use a ploy that I think is fairly sophisticated that causes substantial delay in returning an employee to work after some medical condition or injury. This ploy uses ambiguity as a tool. The employers find certain things about the doctor's note that they claim to be unclear, and they send the employee running back and forth to their doctor to seek answers to questions that never seem to be enough. However, often this is a ruse by an employer looking to keep the employee in a no man's land for significant periods of time and often at a period of time when the employee has no income and they're dying on the vine because they need money to support their family. This ploy works unless people recognize that the interactive process was never intended to be created for the purpose of creating delay. The interactive process, by definition, must be timely, meaning it cannot be used to create delay, but must be done in an efficient manner so that the employer and the employee can get together, determine what can be done to reasonably accommodate that employee and put that employee back to work in a timely and reasonable manner. Another common violation that I see is where an employer will use a generic job description to deny the right of an employee to return to work, where the employee's actual job is not the same as that generic job description. Many employers will create job descriptions for classes of employees. For instance, warehouse worker. And that job description might very well say employee must lift more than 30 pounds on a regular basis. When an employee presents a doctor's note to the employer that says, for instance, cannot regularly lift more than 30 pounds, the employer cannot simply look at that note, look at the generic job description, and say, I'm sorry, you can't do your job, you have to go home, and then therefore refuse to allow the employee to return to work. In that situation, the employer is required to look at what that employee's specific job is within the warehouse. And if that employee's job within the warehouse is to not regularly lift 30 pounds, their job would have the employee regularly lifting 10-pound boxes, for instance. The employer is required then to put that employee back into the employee's old job such that it does not violate the employee's restrictions. And in essence, what FEHA is saying is that the employer must modify or correct the job description for that employee's particular job, which would then allow that employee to return to work. Throughout this video, you've heard me talk about the concept of undue hardship. The last common violation of the Fair Employment and Housing Act that I see quite often is where an employer asserts undue hardship as a reason for not providing a reasonable accommodation to an employee where the employer has engaged in no analysis whatsoever to determine if the accommodation would in fact create an undue hardship. Undue hardship is not mere inconvenience or difficulty or cost or some effect on their other employees. In fact, the law says that undue hardship must involve significant difficulty or expense. Many things that have been found to be reasonable accommodations include the extension of a certain amount of finite unpaid leave to allow the employee to heal and return to perform the essential functions of their job, allowing telecommunication or working from home, transferring an employee to an open position that the employee can do given their restrictions, either with or without accommodation, giving preference to disabled employees over non-disabled employees in transferring employees to another such job, and depending on the size of the employer and other circumstances, upwards of thousands of dollars in cost and the expenditure of a significant amount of time in order to modify the workplace or otherwise make it so that the employee can continue to perform the essential functions of their job. One of the most common forms of avoiding undue hardship or a reasonable accommodation is simply modifying existing policies and procedures. Because the determination of undue hardship requires an analysis of many factors, when an employer simply says that would be an undue hardship without doing the analysis, they likely violate the Fair Employment and Housing Act. The law and the regulations behind the law say that undue hardship is determined by an analysis of many factors, including the size of the facility, the size of the overall employer, the amount of money involved, and things like that. If the employer does not actually engage in an analysis that looks at those factors and then makes the determination of undue hardship, it likely is violating the Fair Employment and Housing Act. My father was the senior vice president of a very large national retailer, and his job was human resources. I grew up in an atmosphere, and I was taught every day that human capital is a company's greatest asset. He truly believed it, and I believe it. I believe that if most employers had that attitude about their employees, that most of what I've talked about in this video would never occur, because the rules that the Fair Employment and Housing Act place upon employers are simply rules that say, look at the specific situation, treat that individual employee as a valued asset of the company, and work interactively with that employee to try to find a way to bring that employee back into the workplace so that they can do the job they're trained to do, even if you have to slightly modify the workplace or the manner in which the job is being done. The Fair Employment and Housing Act is very specific with regard to an employer's obligations, and until more employers in the state invest the time and energy it takes to fully understand the Fair Employment and Housing Act and how it interrelates with the other laws that the employers are required to understand, we're going to see violations of this Fair Employment and Housing Act. If you have any questions about any of the content in this video, I'd be happy to answer them. Please contact me at the address that's indicated below, and thank you.